Hi, welcome to Chambers Expert Focus. I'm here today with Hilary Bricken from the firm of Harris Bricken. Hilary, welcome.
Thanks, Joe.
Okay, we're going to talk quite a bit today about the federal illegality of cannabis versus statewide legislation, regulations, licensing. So firstly, could you run us through some of the most frequently encountered consequences for state licensed cannabis businesses that are federally illegal?
I think the main issue for these state licensed cannabis businesses is the federal illegality and how it impacts their day-to-day business dealings and operations. And there's probably a misconception, I think, maybe globally and domestically, that just because the states have legalized, the federal government is essentially hands off. And that is not entirely true. In the United States, people aren't getting hauled off to prison anymore with mandatory minimum sentencing. The Department of Justice has fully indicated it really doesn't have an interest in treating these democratic experiments that way anymore. However, other agencies like FDA, FTC, the SEC, they still are very mindful of what's happening in the cannabis industry. And that impacts all kinds of things, including access to financial institutions, federal income taxation, the ability to raise money with investors, and really, in addition to having their civil liberties technically on the line, it makes doing business very difficult. They can't engage in interstate commerce. Their trademarks are impacted by this. So it's just this ever-present issue that's not going to go away until we see some kind of big change at the federal level, which for all intents and purposes seems to still be a long way off in the US.
So we're a long way off from the idea of a hands-off federal government in this area.
Completely and totally with full bore ability to engage in interstate commerce and behave like any other business, it is still going to be a long way off. President Biden has indicated that legalization is not on his agenda, and Congress, which could also decriminalize, reschedule, and legalize, they really can't even have lunch together at this point, let alone come up with a bipartisan bill that would legalize and benefit everybody that's already in the industry. So it is a ways off.
Course. So what is the current status of federal enforcement? I think you've given us a peek into that there. If you could say a little bit more about what the current status is of federal enforcement for state legal cannabis businesses.
Well, the US federal government and the states almost have a constant tension on certain points of law and just day-to-day citizen livelihoods, from abortion to immigration and also cannabis, where they do this funky little dance around enforcement. So despite the fact that cannabis is federally illegal, multiple times over the years, the Department of Justice has issued guidance to its own people, namely US attorneys, about how to prosecute these cases and maintain the integrity of the Controlled Substances Act, despite the fact that states are opting out of prohibition. And the last one that we got that really had any meaning for the entire industry was back in 2013. And that memo listed 8 enforcement priorities for the Department of Justice that those fellas and ladies would look for when prioritizing cases. And when I say cases, I mean criminal prosecution. Then in 2018, when Trump was president, we got another enforcement memo that rescinded all guidance and told US attorneys cannabis is a dangerous Schedule 1 drug, and you are free to enforce accordingly in your districts according to your priorities and your resources. Nobody really knew what that meant. If the federal government in each district, different US attorneys, by the way, California has 4, if in every district they would behave differently or if it would be uniform, nobody really knew. But what has occurred, at least as far as the Department of Justice is concerned, is that 2013 memo with those 8 enforcement priorities, that's really what's still in play. And as I said, the Department of Justice, which is in charge with enforcing federal law and arresting people and prosecuting them, they are not really interested in going after these cases and essentially wasting resources and manpower going after state law experiments. So we're not going to see activity from the DOJ. But as I mentioned, the other agencies, depending on the topic, may be quite active or dormant. It just depends on the agency and, frankly, the timing and the politics.
So given the state at a federal level, or rather the status of things at a federal level, what is the status regarding cannabis businesses securing bank accounts?
I would say this is the biggest issue in this legal penumbra next to paying taxes. And the reason is because we have federal illegality, financial institutions cannot openly or lawfully touch these businesses. All of the revenue that flows from these businesses into the banks would be laundered under the Bank Secrecy Act, and the financial institutions would be aiding and abetting and conspiring to violate the Controlled Substances Act, obviously our federal law here. So the ability to get a bank account is very difficult. And I don't know about you, Joe, but running businesses on an all cash basis, trying to make payroll and paying your taxes, it's pretty painful. And that's why, as legal tender, it's kind of gone out of fashion. It's difficult to manage and it's hard to trace. And there's also a lot of nefarious behavior around it anyway for those reasons. So in 2014, and this again goes to how the feds are doing this little dance with the states, Treasury, our Department of Treasury, which is separate from the Department of Justice, issued a memo to financial institutions that if they want to bank in this industry, they have to follow very strict guidelines around know your customer legislation and rules. And what that means is that the banks that do decide to extend a bank account, they are still in violation of federal law. They are still laundering money, but the feds know about it. And there is a very detailed suspicious activity report system that they have to follow so that the DOJ, the IRS, they are enabled with this knowledge of these companies to determine if anyone's engaging in tax evasion and other nefarious behavior just based on the movement of money. So there is an ability to obtain a bank account. It's still very difficult. You have to be licensed, fully compliant, lots of disclosures to your financial institution. But for all intents and purposes, our banking laws in the United States do not lawfully enable this relationship. So all of that hinges on the back of a federal enforcement memo from Treasury, which could be rescinded at any given time.
Okay. And has that had any specific knock-on effect on the banking industry and the way that banks, either new challenger or existing banks, are formatting the way that they work in the cannabis sector or work with the cannabis sector?
Yes, it has. In order to bank these customers, you need to beef up your bank secrecy team and your KYC team, and that is expensive. So not a lot of financial institutions are participating. At last checked, it was probably 750 plus. That's not a lot of financial institutions, and it's mostly regional banks and credit unions that see this as a business opportunity to grow this particular portion of their portfolio. But Wells Fargo, Chase, Bank of America, they want nothing to do with it. They don't need it as a line of business, and they're not going to compromise themselves before the federal government. So it really is an opportunity for smaller businesses and banks, which is a problem on the back of Silicon Valley Bank, in that a lot of our small banks are now being threatened for obvious macroeconomic factors. So if they go down even more, that'll indicate further lack of access to financial institutions, which will harm these businesses overall.
And what's the current federal income tax situation for cannabis businesses?
Yes, so many cannabis businesses in the US believe that just because they're violating one federal law, they have a license to violate all federal laws. Not the case, obviously. And you do still have to pay your taxes on illegally gotten gains in the United States. That is a rule with the IRS. And many people, I think, have forgotten that Al Capone went to jail not because of the bootlegging and the rum running, but because of tax evasion. So you better pay your taxes even on your illegal market money. And here in the US, it's Internal Revenue Code 280E as in Edward. Basically, what it says is that if you traffic in a Schedule 1 or 2 controlled substance, and cannabis is Schedule 1, you are not allowed to take normal deductions. All you get to take are cost of goods sold, which if you traffic in cannabis, if you're a retailer or a distributor, 90% of your day-to-day business is simply trafficking, as opposed to a cultivator or manufacturer where they're actually making the good. They can capture more cost of goods sold. You're looking at an effective corporate income tax rate of about 70 to 80%. So that, combined with the inability to bank, makes it very difficult to make money in cannabis without being high volume and really mastering economies of scale. And right now, economically in the US, the cannabis industry is suffering because it's a race to the bottom to compete with the illegal market. And on top of that, you have these onerous obligations from the IRS. States are beginning to change their own codes so that there's no 280E effect at the state level. But again, without a change at the congressional level, the federal level, this particular law will continue to plague these businesses and potentially even ancillary businesses that help them traffic in perpetuity.
And as a follow-up to that, I think you alluded to it there, but what does that mean for the two of the biggest words that we come across in this sector, which is vertically integrated? That's something you touched on there. Those bigger businesses. It sounds as though that's maybe an advantage in this sector now.
I think that's correct. The reason being, if you're vertically integrated, you can take more cost of goods sold to offset your retail footprint and your distribution footprint. But from a cultural perspective, and what we've learned from big tobacco, big alcohol, big pharma, do we really want these large monopolies basically taking over the cannabis industry? And I think that's being debated state to state to state. The preservation of the small business that probably in the long run can hardly hack it with these issues versus the larger player that's got a ton of accountability and has a better ability to bear the current legal landscape. And I don't think we have a decision yet on culturally and from a health and safety perspective, a consumer perspective, what the better way to go is. But certainly being vertically integrated, which is expensive and tough to manage, would help offset those 280E issues.
And what about other companies, third parties, such as investors that are working regularly with cannabis companies? What are their concerns? What do they have to worry about in this climate?
This is interesting because a lot of investors believe that they too have no liability for just passing funds into these companies, and that is also not true. As an investor, when you make that capitalization, when you make that loan, even if it's a convertible note where it starts as debt and converts into equity at some point, you are aiding and abetting and conspiring to violate the Controlled Substances Act. Your contribution is enabling the drug dealing as far as the federal government is concerned. So they have ancillary liability that they have to be worried about. And on top of that, because it's federally illegal, it has this quality where it attracts folks who have been in the legacy market, meaning pre-licensing, that have now converted into licensees, and there can be a real lack of business acumen. They may know how to cultivate cannabis at a very high level, but they've never run a company. They've never managed employees. They don't understand how to read a profit and loss statement. And that lack of knowledge, also setting aside the criminal liability, can make it a very precarious business prospect. And I think a lot of the stupid money has left the market as many of these businesses have failed. And now investors realize they need to do traditional due diligence and really put the feet of the founders to the fire to determine if it's a wise investment, not just because it's cannabis, which is part of a big fad or a huge trend. These businesses need to be competitive and try to compete with each other at a normal rate like we see in other industry, despite the federal issues.
Um, one more question. I was just wondering regarding the interplay between federal illegality and intellectual property belonging to cannabis businesses. How do those two things impact one another?
Well, they do not get along at this particular point. And again, because of the federal conflict, this is a day-to-day issue that entrepreneurs may not consider, but the United States Patent and Trademark Office will not register trademarks if there's no lawful use in commerce. And because cannabis cannot cross state lines, it can only stay in its little state borders, we do not have lawful use in commerce. And potentially there are even morality issues, and that trademark standard adheres to that, where cannabis may be perceived as offensive, nefarious, not capable of registration. So you can't get a federal trademark for your direct cannabis goods. Ancillary products, glass, hats, t-shirts, that is on the table. But strain names, product names, or cannabis trademarks that really go towards the core of the product itself, you're not going to get that protection with the USPTO, which means in every state in which you go and you establish a licensed business or you have a business partner there with a licensed business, this is where you would have to register your trademarks with the state. And a lot of businesses, I think, in just normal commerce, they don't even contemplate registering a mark with state government because they can easily get the federal mark to protect their trademark in all 50 states. So cannabis, again, it's a headache, it's a pain point. To protect your IP, you cannot look to the federal government for that very good suite of protections that you'd normally otherwise get.
So I guess another area in which the protections of the federal government are not necessarily as the businesses would like, and the actions of the federal government are not as predictable or as predictable as businesses would like either.
Yeah, fair statement. So, as I said, people are not getting hauled off to prison anymore, but their daily business lives are no easier because the federal government is not going to play ball on these lucrative business issues like access to financial institutions, taxes, trademarks, and then, of course, institutional investment. That also is not really happening because those individuals have to answer to their investors and they can't say, hey, I just signed up the fund to contribute to what the feds would call a massive drug ring. Don't worry, there's no issue. It's all political. That doesn't tend to happen. So most of the investors in the space are independently wealthy, or they're very, very small funds that are looking for emerging markets and they're willing to take the risk.
So not necessarily the easy money that this business was maybe thought to be a few years ago.
Correct. I do think that the euphoria of the green rush has evaporated, and now these companies actually have to work for this money. And the leaner they get, the worse the economy gets around them, the harder it's going to be to net those dollars anyway.
Well, thank you very much for your time today, Hillary. That was really useful and really helpful. Thank you.
You're very welcome.